Please, Your Lordship.
Yes.
Yes, may I please? I begin item number 6 and 7, my lord. I'm appearing for item number 7, my lord.
Okay, right. On the prayer for adjournment made on behalf of Mr. H.R.A. Chaudhary.
D. Bora, my lord.
Huh?
D. Bora, my lord.
G. Bora, learned counsel for the
Appellant, my lord. In item number 7.
appellant in criminal brief 49 of 2020, which is not objected to by the other side. This is the matter after.
After 2 weeks, ma'am.
Okay.
Obliged.
Both of them.
Yes, ma'am. They are taking matter, my lord. That's not been arranged. Therefore, item number 6, ma'am.
Other than
Obliged.
Sharma, Miss Sharma, you are here. What are the matters?
Lordship, this matter which is being mentioned.
Huh?
Yeah,
I
legal
asked for the respondent number 2.
In which one?
In item number 6 and 7 both. I am not Sharma.
legal aid counsel, ma'am.
Okay, yeah. So, why is it tagged together? This is-
Same matter, my lord.
Two persons have.
My lord, yes.
So why you adjourning the matter?
Do we have some difficulties, ma'am?
Show me this item 7. We cannot allow adjournment for the sake of adjournment.
My lord.
Last time also they were.
All because of all. Okay, the last two adjournments have been made by you.
My lord.
Right. We have noticed that the last two adjournments have been made on behalf of the appellant. Today is the third consecutive adjournment made on behalf of the appellant. List the matter on Facebook. No further adjournments will be given on September.
My lord. Obliged.
May I please, Your Lord? I have to mention for listing of a criminal appeal of 2019, my lord. It was coming to the hearing list. All of a sudden, it is dropped now. So it may come up in next week.
What is the matter about?
Conviction, my lord.
Actually, conviction with what?
Conviction for live imprisonment.
What is the charge? What is the case? Murder?
302, my lord.
Huh?
302, my lord.
Do that. Give a date. March.
Obliged, my lord.
May I please, Your Lordship? Your Lordship, I beg to mention item number 8. Kindly pass over the day, Lordship.
Why?
Lordship, Mr. H.R.A. Chaudhary has some personal difficulties, Lordship. Leave notice there, Lordship.
You've noticed there.
Yes, Lordship.
Right. On the prayer for adjournment made on behalf of the Israeli government. This is the matter after a week.
Okay.
Yes, item 9 also. Anyway. Any report from the family court?
Yes, probably it has been sent now.
There's no report, I think.
The entire record has been sent, that is what I'm saying.
I was also.
We wanted a report.
Otherwise, the payments were clear,
Huh?
The payments are clear, so far.
Payments are clear.
Yes, sir.
20th
What do you
one.
want?
The only
The
thing,
payments are clear.
Yes, Your Lordship.
Oh, then it's all right.
only thing, here, what is the payments are required to be made on dates, If the lordship goes to the order sheet, you'll find, there is a criminal.
So payments are clear.
Yes, yes, payments are clear.
So basically, they are against the enhancement of the monthly.
Not enhancement,
Huh?
not enhancement. Our condition is basically, she left me.
An appeal by the department under section 35G of the Central Excise Act laws.
Yes,
The appeal is to be admitted on question of law if Lord is satisfied. Lordship, I had submitted 3 questions of law for consideration of Lordship.
even a copy.
No, Lordship. No. Lordship, what happened here? Notice, demand notice was issued to the respondent. Then order in original demand was confirmed. Thereafter, the respondent approached learned tribunal. Tribunal has reversed the order, stating that we have violated the circular by which pre-so-called consultation is necessary. Lordship, subsequently, another notification was issued on 11/11/2021, where in clause 5, some exception was clause 5, Lordship. There is a clarification to earlier notification by which Lordship pre-so-called notice consent was made necessary. Clause 5, it is therefore declared that the pre-so-called notice consultation shall not be mandatory for those cases booked under Central Excise Act or Chapter 4 of the Finance Act 1994 for recovery of dues or tax not levied or paid short levied or fraud paid or erroneously refunded for reason of A, fraud, pollution, C, willful misstatement, D, suppression of facts, E, contravention of the provision of sanction. Here, Lordship, in demand notice, all these allegations were there. However, learned tribunal has come to conclusion that we have not followed our own circular, but this circular was not taken into consideration. Whether it was placed or not, I'm not aware.
So, my lords, before I start, may I take you lost to the brief facts of the case?
Yes, sir.
My lord, the case is that, my lord.
Solo.
Lordship,
Yes, my lord. I think. So, my lord, what has happened is that, my lord, we had done a number of activities from the financial year 2014-15 to 2017-18. All the activities we had done were covered under a mega notification which was floated by the government of India. My lord,
14, 15 and 2000.
2000 from financial 2014-15 to financial year 2017-18. All the activities we were carrying out were exempted from service tax by a mega exemption policy which was floated by the government of India in 2012. My lord will find that in my objection in page number 84. Under entry 12, 12A, 13A, and 14. My lord, at page 87.
Yes.
So, my lords, because of this, these
Yes.
exemptions were provided 12, 12 capital A, 13A, and 14.
Yes.
So, my lords, in view of this exemptions were granted to us, naturally, when we filed the ST3 returns, we filed nil ST3 returns because we were exempted from the purview of service tax.
Nil what?
Nil returns, ST3 nil returns, service tax 3 nil returns. Now, my lord, surprisingly, in 2019, the adjudicating officer issues a demand come show cause notice.
All your services were covered by this 12.
All the works, my lord, yes. So, my lord, what happened is that in 2019, the adjudicating authority issues a demand come show cause notice. First one,
Eight.
page number, my lord.
17 demand sub.
17, my lord, in their appeal. In their memo of appeal, page number 17.
Seven. E.
7, 1 second, my lord.
1 7.
1 second.
Yes.
So, my lord, pursuant to this demand come show cause notice, we appeared in person before the adjudicating authority and told our part of the situation that the activities we carried out were exempted because of this policy. We also produced our work orders. But, my lord, the adjudicating authority passed the order in original which is at page number 29, confirming the demand so made in this demand cum show cause notice.
This is demand come show cause notice 21/10/19.
Yes, my lord. The demand cum show cause notice was 19, and thereafter order in original was passed in 2021, 22/10/2021. That is at page number 29, my lords.
Yes, where is the operative portion?
The operative portion, my lord, will find that.
Page 37, Lord, see?
37.
Discussion and findings.
Discussion and findings.
Ah.
So, my lord, basically what they are saying is that although we had given the work orders, but we had not given the invoices. That is what this adjudicating authority had come to the conclusion. Without making a clear-cut analysis of the activity that we were doing.
You had given the work, the
work
work order
order.
of the service done by
All the
you.
services that everything we had done from financial year 17, from 14-15 to 17-18, all the works that we had rendered, all the work orders we submitted before the authority, and we could not submit the invoices because COVID time was going on. Then those are voluminous invoices, so we could not submit those invoices before the adjudicating authority. But the adjudicating authority confirmed the demand so raised by in the demand cum show cause notice. We preferred appeal before the CSTAT. In the CSTAT, my lords, we gave all the invoices. My lords, in fact, if my lords go through my CSTAT,
Okay, you never gave it to the authority, you gave it to CSTAT.
we gave it. No, my lords, we gave the work orders to the authority. The
But you did not give the
invoices
invoices.
we gave for the CSTAT.
You never gave it to the authority.
My lord, but the CSTAT being the highest fact-finding body,
Maybe.
my lord. So, my lord, evidences can be introduced for the first time also before the CSTAT. Evidences for the first time can be introduced before the CSTAT. My lord, there are judgments. Even for the first time, it can be introduced before the CSTAT. My lord, when we gave our numerous judgments, my lords may kindly have from page 131 of my objection. These are, my lords, all the invoices that we had submitted before the CSTAT for all the works that we had done. Page 131 to 134 is, my lord, for 14-15. From 135 to 137 is for 15-16, and so on and forth. So, my lords, before when we had filed the invoices before the CSTAT, they never raised the objection that either of the bills that we had submitted before the CSTAT is not covered by the exemption so made in the policy, in the mega notification policy. Even in this memo of appeal, my lord, they have not pointed out one single bill which is not covered by that exemption policy.
So what did
So now, my lord, the CSTAT has come to two conclusions. The first conclusion, my lord, if I take your lordship through the impugned judgment, my lord, at page 61 of the memo of appeal.
What is this page 131?
131, my lord, is the invoices that we had submitted, the copy of the appeal.
One is the invoice.
Yes, my lord. That we had submitted before the CSTAT.
So page.
Page 61, my lords, of the memo of appeal. So basically, my lords, the CSTAT come to allowed a repeal on two grounds. Number one is that they had conducted a hovering inquiry on the basis of 26 AS statements to come to a conclusion that we had evaded service tax. The department. If the department is claiming that we have evaded service tax, there has to be some credible evidence. Form 26 AS statements cannot be the basis. This is a settled position of law. And the second ground that the CSTAT allowed a repeal was the issue just argued by my senior, that is non-issuance of pre-show cause notice consultation, which was mandatory in terms of a circular dated 2017.
Non-issuance of pre-show cause notice.
Consultation.
Pre-show cause consultation.
Pre-show cause notice consultation.
Under what provision?
There was a circular, my lord, issued by it's a ADR, Alternative Dispute Resolution to facilitate trade and promotion. So the government of India had come up with a policy. I'll give a copy of it.
That 2017.
17, my lord. Copy data. 10/3/2017.
2017.
Is the service tax that you are demanding
Notes.
is with regard to the services rendered till 2019.
Yes, sir.
Okay. Now the document that you have produced now, which does away with the pre-show cause notice, has been issued in 21.
Lordship, there is a judgment to that effect that this is already clarification. So it will take effect from the when the circular was issued. The BBF judgment is there, but I have not brought that judgment. That is clarified that any clarification issued that will be accounted from the date when the original notification is issued. This is nothing but a
What?
clarification. And in.
What do you mean? You mean to say that the 2017 notification
Yes, Lord.
does not require a pre-show cause consultation notice?
Yes, Lordship, in view of circular dated 11/11/2020. What's my please to see?
You mean to say it has been given retrospective effect? Or do you mean to say that the 2017 notification and the 2021 notification are one and the same?
Yes, Lord.
It is one and the same.
Yes, Lord.
Let us see.
Lordship,
Give us the 2017 notification.
Lordship, that judgment has
My lord,
not got.
But my lord, that will not have any,
The
my lord, that will not have any material effect to the case because they are alleging fraud. I will take your lordship through because my fraud, as per section 70 of the Contract Act, fraud has to be there when I have purposefully concealed some statement. When I have the bona fide belief that the activities that I had rendered were exempted from the purview of service tax. There cannot be fraud, my lords. Because I am under the bona fide belief.
Under which section?
17 of the Contract Act, my lords. Fraud is defined.
What's me pleased to see this demand circum notice where we have there is a sufficient
No,
material.
but my lord,
Let me see the 2017 notification and 21 notification. 21 you have given us.
Yes, Lord.
Now let us see whether that 17, okay, this is the 17. Whether it is the, what does it say, 17?
17, my lord, is at clause number 5.
Pre-so-called consultation is mandatory.
Page 4, clause 5.0.
Yes, sir.
So if it's mandatory and this 21 says it is not mandatory, how do you reconcile the two? It means that they're different.
No, Lordship, pleased to see the subject of the notification 11/11/2021.
No, let us see 10/3/17 first. Where does it say it's
Clause
mandatory?
5, my lord.
5.
Page 4. Consultation with the noticee before issue of show cause notice. Board has made pre-show cause notice consultation by the principal commissioner prior to issue of show cause notice in cases involving demands of duty above rupees 50 lakhs except for preventary offences related SCNs mandatory but instruction issued from F number so and so dated 21st December 2015. Such consultation shall be done by the adjudicating authority with the SEC concerned. This is an important step towards trade facilitation and promoting voluntary compliance and to reduce the necessity of issuing show cause notice.
Okay, so the CSTAT, one of the ground,
This was the second round.
huh?
This was the second round.
In the second round.
Yes, ma'am.
Second round is that the pre-show cause notice
Yes.
was not given.
Yes.
So now let us see, one minute, let us see.
Page 17.
Huh?
The CSET's order.
Huh?
CSET's order page.
No, what he's saying, you are not objecting also.
Not
You're denying, not denying. So forget that. Let's go to 11/11/21 order.
Lordship, paragraph 5.
Paragraph 5. Paragraph 5.
It is therefore reiterated that the pre-so cause notice
Shall not be mandatory.
shall not be mandatory for those cases booked under Central Excise Act or Chapter 5 of the Finance Act 1994 for the recovery of duties or tax not levied or paid or short levied or short paid erroneously refunded by region of. There are 6 regions is there.
And you see this, okay, now as per 21, according to you, 21, he comes under 21.
Lots.
Correct. Now, let us, before going to 5, let us go to 2.
Lordship. Yes, para 5 of
Para 2.
para 5
Ah.
of the master circular dated 10/3/2017 merely reiterated the principle of pre-so cause notice consultation initiated by memo aforesaid mentions instruction dated 21/12/2015 further by circular dated 19/11/2020. It was clarified that pre-so cause notice consultation with SEC prior to issuance of SCN in case of demand of duty is above rupees 50 lakhs explore the previous office related SCNs is mandatory and shall be done by the so-called notice issued authority.
Correct. So, even as per the notification circular of 19/11/2020, which has not been produced, it was mandatory.
Yes, it was mandatory.
It was mandatory.
Yes.
Now, let us see. So, according to, in your case, you have not submitted any pre-show cause notice?
Yes, sir, it is correct.
That is correct.
Yes,
Now, where is the authority? When did he pass his order?
Lordship.
After the show cause notice, there was a show cause notice issued.
Yes.
Now, show cause notice was issued on
Lordship, it is
On
on 21/10/2019.
notice on the show cause notice on 21/10/2019.
Lordship.
And then the order of the authority, where is that?
22/10/21.
Where is that page?
Page number 29.
Page 29. 21/10/2021.
And this notification is, my lord, dated 11/11/21. So the date on which the order,
That is what I'm looking at.
the date on which the ordinary was passed, this circular was not,
11/10/21.
this clarification was not.
So, by the time the authority had issued the, that is at page 36, 30, where is the finding? Okay, 37, 38, 7, 38, 39. Where is the end?
Which one of this?
Where does it end?
So-called notice or Lordship order in origin. Let's start from page 29.
And ends at page 57,
Page 58.
59.
59,
58 is
Sorry, my lord, 58.
58.
58, my lord.
then 60th order is start from page 59.
So this is by the principal commissioner,
Commissioner CGST.
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 So, this order that is under challenge was issued prior to the notification of
No,
November 21.
Here,
It is
order,
not applicable.
here, Lordship, order of the CCT is under challenge.
Huh?
Order of CCT is under challenge.
That is all right, but we are going to the first initial thing. You see, at the time, the entire issue started
This notification was not,
from this date of issue of the order dated 22/10/21.
Lordship, that's why I am submitted that Supreme Court says that is merely clarification. So it will affect from the original notification. Lordship. Lordship,
But my lord, even on the first ground, the CSTAT has dismissed our, allowed our appeal on 2 grounds. This is the second ground.
Ah.
Even if I go to the first ground, I'll satisfy my lord that there is no case for appeal.
How is the first ground?
First ground is that, my lords, that before alleging, if they're alleging that we are evading service tax, they have to come out with something credible evidence. They have merely gleaned on the 26A statements and said that we have evaded service tax and put the onus on us. So, Martin, my lord, as per 101 of the Evidence Act, if they are alleging something, the burden of proof is on them to discharge. So, may I take your lordship to the operative part of the first finding of the CSTAT?
Yes.
Page 62, my lords, para 7. May I read your lordship?
Yes.
The appellant submits that they have undertaken various works as per the work orders given by the PWD authorities, Airport Authority of India, Indian Railways and All India Limited in construction, erection, commissioning, installation, completion, fitting out, repairs, maintenance, renovation or alteration of a road, bridge, tunnel or terminal for road transportation for use by general public. These works are exempt under entry number 13A, 12 capital A, 14 of the exemption notification number 25/2012 dated 28/6/2012.
So These works are this under 2012.
Yes, my lord.
This was
The exemption was floated in 2012. That policy that I have just shown, my lords.
You have shown us 2017.
No, my lord. The policy that we are covered under, the exemption policy,
That
That
is
is
of 2000.
2012.
Okay, the exemption policy is.
Mega exemption policy.
That is a page 12A.
984, my lord.
Huh?
84.
No, page 87.
Yes, my lord. 87 is the entry. 12. Yes, my lord. Yes.
87,
12 capital A.
87, 87. But where is the beginning of this mega exemption? The notification of
84 is the beginning, my lord.
the minute. The exemption notification of 12 June 2012.
Yes, my lord.
And you were taking us to which page 62 right now?
The relevant portion is at 87, but it starts from 84.
26. No, 20. This is the same. Okay.
May I read, my lord?
Ha.
The part of the CSTAT judgment. On going to the order in original, we find that the learned commissioner has confirmed the demands as per the receipts by the appellants as indicated in 26A statements, copies of work orders wherever submitted by the appellant. Learned commissioner's finding on each of the heading of the works during the various financial years are that, however, the noticee failed to submit copies of invoice, bill payment, voucher for correlating the payments so received by him and the nature of work executed. Therefore, the benefit of exemption under notification number so and so dated 28/6/2012 cannot be extended as claimed by the notice. And that, therefore, I have no other option but to maintain the allegation within the show cause notice. We find that the manner in which the allegations were raised in the show cause notice and confirmed by the impugned order is not legally correct. My lord, this part is the finding. We find that as the department is alleging that the appellants have evaded payment to service tax, it is incumbent upon the department to prove the same with reliable evidence. We find from the impugned proceedings that the details of payment received by the appellants were gleaned from 26A statements and other documents like ledger, profit and loss account, balance sheets, etc. Thereafter, the appellant were asked to submit the necessary details like work orders, invoices, etc. No other investigations to prove that the appellants have rendered taxable service and received remuneration for the same were conducted. The department has not even bothered to collect necessary documents from the respective government authorities at whose behest the appellant is alleged to have undertaken the works orders. The nature of such works alleged to have been undertaken by the appellants, the taxability thereof, under Finance Act 1994, and exemptions, if any available, was not discussed at all in the impugned order. The appellant's contention that the works undertaken by them were on behalf of the government department and for use of general public, and the same were exempt by notification number so and so dated 26/2012 were not at all considered and discussed. Under the circumstances, we hold that the department has not discharged its onus.
28/6 or 26?
206.
It should be 20, na?
They should be 206. Typological error.
Typical error.
Typological error. Were not at all considered and dismissed and discussed. Under circumstances, we hold that the department has not discharged its onus to prove that the appellant is liable to pay service tax. It is a settled principle of law, my lord. Now, this part, it is a settled principle of law that unless and until the clear analysis of the activity done by the SEC is carried out, demand of service tax cannot be confirmed. Now, my lord, there are judgments way back, starting from way back from 2007, from Kelvin Woodings. The 26A statements cannot be the basis on which they can impose evasion of service tax upon us. There has to be some other credible evidence. May I take your lordship through one of the judgments of the recent judgment of the CSTAT, which has again reiterated the judgments from 2007. Contextual to that. Contextual enterprise.
$26
26A statement, my lord.
So all the
In fact, my lord, on the
terms in the form 26A cannot be the basis.
yes, my lord. So, my lord,
To a finding as to whether there has been
evasion of service tax.
evasion of service tax.
I'll give the reason behind that, my lord. Because income tax and service tax are two separate central acts in operating in the independent domain. So the reason that I am paying income tax will not be the reason that I will also have to pay service tax. And those have been discussed by the CSTATs, the Honorable High Courts, and also there is a judgment of the Honorable Supreme Court. So first of all, my lord, I'll take your lordship through a judgment of the CSTAT. This has categorized and summarized all the judgments way back from 2007. The facts are also very similar to our case. They were exempted from this
What is this 26 years?
26 statements, my lord, is a consolidated statement wherein all the tax that has been deducted will be there. It will be uploaded on the income tax portal for the taxpayer to view. And sometimes it's shared with third-party data, like the service tax department. My lord, in fact, had raised a query on the last occasion. If my lord go to the order dated 8/12, my lord wanted to know the basis on which 26A statements were issued. So, my lord, 26A statements are issued under 285BB of the Income Tax Act. And if I may give a lordship to one of the 26A statements for my lord's understanding. In this 26A statement.
Yeah.
This is the 26A statement, my lords, of the petitioner for the financial year 2014-15. Now, my lord will find that the deductors, the name of the deductor, because these deductions were made under 194C of the Income Tax Act, because I had carried out work contracts. So all these authorities, Assam State Road Board, Bharat Ispat, Deputy Commissioner, Dibrugarh E&D Division, NF Railway, EPWD, Dibrugarh Roads Division, Tinsukia State Road Division, they had deducted while making us the payments for the works that we had rendered, they deducted TDS. And this is a statement of those TDS statements. But this cannot be the basis on which that I am also liable to pay service tax. Whether the works that I've carried out here, whether they are actually exempt from the policy, I mean the notification which was floated in 2012, that has to be carried out. That was not done.
Okay.
So this is the basis, my lord. Now, my lord, may I take you to the...
So without doing that exercise, they have basically
They have put the blame on us.
They've used all this data
Yes, my lord.
without considering whether they come under the 2012 policy.
Yes, my lord.
12, 30.
Yes, my lord. And then when we submitted the bills also before the CSTAT, they were raised.
You should have submitted before the principal commissioner. No?
My lord, we did submit the work orders.
What?
We did submit the, but my lord, from a bare deal,
What's the difference? So would the work orders be enough or the invoice would be enough?
my lord, they are saying, according to us, my lord, first of all, the onus is on them to discharge. They had simply put the burden on us that you are evading service tax. Now you submit all these documents. That cannot be the way, my lord. They have to come up with credible evidence. They could have, might as well investigated with these agencies because all of them are instrumentalities of state. PWD, Indian Railways.
Show us where this 2023 case.
My lord.
Kankeshwari.
My lord, Kankeshwari Enterprise.
Kankeshwari.
My lord will come from para 5.1.
Yes.
May I read, my lords?
Yes.
We find that there is no dispute on the facts on either side that the appellant had the service tax registration so and that appellant have provided the service to the government authorities agencies. After issuance of show cause notice, there is so for the financial year 15-16 to 16-17. Appellants have also participated in adjudicating proceedings and have made submissions with documents like balance sheet, profit and loss, work orders, invoices issued, agreements of their subcontract, their financial records for the financial year 15-16 to 16-17, including detailed ledgers, etc. Appellants have submitted that they are eligible for exemption, availed and reflected in their ST3 returns and the state to drop the service tax, entire service tax demand, in this case, issued unduly invoking extended period for the total demand of service tax. We find the learned commissioner have issued show cause notice on the basis of 26 AS data for demand of service tax for financial year 15-16 to 16-17 as under. The values there, my lords. Thereafter, the impugn order in original dated 49/22 has confirmed the demand on the following calculations. Again, my lord, the values are there. Thereafter, my lords,
Also, there is no pre-show cause notice.
there is no that is not an issue, my lord, out here. They are not raised this issue. Thereafter, my lord, in para 5.3, we find that it is settled by now that without conducting any independent inquiry or investigation, the demand of service tax cannot be sustained only on the basis of 26 AS data provided by income tax authorities to central excise officers at Bhavnagar. Service tax demand cannot be raised on the basis of assessment by the income tax authorities. There is no dispute on the fact that a show cause notice for demand of the service tax is solely on data TDS 26 AS of the appellant in income tax returns for the financial year 15-16 to 16-17, which is shared by the income tax authorities. Declarations under Income Tax Act are annual consolidated tax statements. Income tax and service tax are two different and separate and independent special central tax, and their provisions are operating in two different and independent fields. By relying only on 26 AS data of income tax, demand of service tax cannot be made. My lord, therefore, the CSTAT discusses a number of judgments way back from 2007, as I've been submitting, my lords.
So this is basically the law.
Yes, my lord. So then my lords may kindly come to page 10, my lord. In fact, all these judgments, my lord, were also relied
Para.
page 10, para 5 point. Huh? It will not sir. Index or my lord, my lord's copy and my lord copy may be different.
Para. So just give us the para.
5.6, my lord. In the above discussions, it is consistent. My lord has it. Page number 10.
We don't have page.
Do you want to see? Yes, my lord. In the above decisions,
It is the consistent view.
it is the consistent view that demand of service tax on the basis of shared data of TDS 26AS 3CD statements are not sustainable. We note that it is settled that service tax demand cannot be raised only on the basis of any such assessment made by the income tax authorities. Information or data or documents relied upon losses is evidentiary value in absence of any independent inquiry which was mandatorily required to have been conducted by concerned officers of Central Excise Department in Bhavnagar before issuance of show cause notice dated so and so. Further, the data provided by the income tax authorities does not appear processed in terms of Section 36A or 36B of the Central Excise Act made applicable in service tax matters by Section 83 of Finance Act. Further, my lords, this part is important. Further, the data provided by income tax authorities simply show the details of income received from sales of services and service tax paid thereon. However, in income tax returns, no further details of exemptions availed on service requires to be declared. Hence, there may be mismatch in data of income tax vis-a-vis service tax return depending on the tax of the case. Thereafter, my lords, the paragraph next, the one preceding that at 5.6. In the facts of the case, my lords have this.
Yes.
In the facts of this case, the SCN dated 19/4/21 has been undisputedly issued only on the basis of 26AS data shared by income tax. There is no reference in SCN of claim or validity of any exemption or details of actual service provided by the appellant. When the service tax is demanded on alleged service by SCN, it is obligation of revenue to show that appellant had rendered such services to customers with the evidences. In the present case, department has failed to do so. Section 65B, surplus 44 has provided definition of service, but various services were also placed in the negative list under Section 66D, not attracting service tax, and there were many services which were allowed exemptions from service tax under notification number 2012 ST and many other notifications issued. Hence, it is interpermissible under law to any baseless SCN on assumption or presumptions, and later on SCN can be improvised by order in original adjudication. Appellant is registered service provider. His service tax payments ST3 returns on record and available with department authorities issuing SCN dated so and so. Did not even verify such details before issuing SCN. When communication dated so and so issued by the superintendent of Central Excise, which appellants are not received by them, the Act rules has provided unlimited powers. My lord, again, this part is also important. Provided unlimited powers to Central Excise officers to search premises of appellant and to seize documents and collect evidence before issuance of SCN to frame correct charges against appellant on alleged evasion of service tax. In this case, officers have chosen not to exercise such unlimited powers to establish case of evasion of service tax against appellant. It was necessary for the department to specify activity and nature of service that was to be taxed under specific clause of services or declared services described in the Finance Act 1994. The case law cited by the appellant hold that revenue cannot argue a case which was not made out in the SCN, and adjudicating authority cannot travel beyond the SCN, as the law settled by plethora of decisions by tribunals and higher forums. The decisions relied upon by the appellant support this view.
Wow. Let us see what the show cause notice is.
Yes. My lord, page number 17. My lord, can I have some water?
Lordship, before my learned friend starts, Lordship, I come to page section 35G of Central Excise Act. Thirty-five G. Probably page 86 of this book. Lordship? Yes, Lord. What happened earlier, the section was deleted in view of the National Tax Tribunal Act, but the Supreme Court revived that. Lordship. The section was again revived.
Yes, it has been divided.
35G3 Lordship. 35G3.
35 G
Three.
3. We don't have it here out there as three.
It is there, Lord. Below. Where
Yes.
where the High Court is satisfied that substantial question of law is involved in any case,
Yes.
itself formulate that question.
Correct, so.
Then 4,
Yes.
the appeal shall be heard only on the question of formulated, and the
Yes.
respondent shall, at the hearing of the appeal, be allowed to argue the case does not involve such question.
Correct. That is what we're doing. Whether it involves any question of law.
Lordship, here I have submitted 3 suggested substantive question of law.
So we are seeing the facts of the case and we are going to
No.
consider that
Now, Lordship,
in
If your Lordship-
with regard to your proposed substantial questions.
yes, Lordship, correct, Lordship, that I am not, but my Lordship submission is that there are, I have submitted 3 substantive question of law. First, Lordship, regarding circular of 21. Lordship, in this regard, I want to place one judgment of honorable.
You can ask a junior to get it now.
Now, Lordship, already I have given Lordship.
Okay, very good. We let him finish. Let him finish. Yes.
Yes, my lord. So, my lord, the show cause notice, my lord, will find in page number 17.
Yes.
My lord, at page 18, the documents, records as obtained from the income tax authorities on, my lord has it?
Yes.
The documents, records as obtained from the income tax office on 24/9/2019 RS below. Copy of the form 26 AS income tax for the period 2013-14 to financial year 17-18. So, my lord, this is the only document that they are relying on. There is nothing else. So, my lord, if this,
Okay, that is that. Now let us find what is the finding of the decision of the principal commissioner.
my lord,
Where is that? The final decision and the basis for the same.
so, my lord, we had given the thing.
So even the principal commissioner was not given the invoices, correct?
Principal commissioner was given the, may I take a lordship to what we had submitted?
Ah, yeah.
Start from page 37.
My lord, at page 36,
Yes.
submission of the notice.
Yes.
The notice submitted a written reply dated 23/12/2019, received at this office on 2/1/2020 to the instant demand cum show cause notice wherein he has stated the following: that he is a contractor having service tax registration number so and so, and that he had been submitting his service tax returns regularly in form ST3. He also submitted that he had been executing various works, contracts for the government department for the period 1/4/2014 to 30/6/2017. The entire work contract executed during that period were exempted from the purview of service tax in view of the provision of 66B of the Finance Act 1994. The noticee has also submitted the details of the work contract executed and the relevant clause of the section along the nature of the contract executed. As the work contract executed were exempted from the purview of service tax, no tax liability arises on account of service tax. No demand of service tax can be made, and consequently interest and penalty should not be demanded. In support of the claim, the noticee submitted the following documents: 26 AS wise details of amount received from different contractor organizations, copy of Form 26 AS, work contract order of the works executed, certificate of registration with the Assam Public Works Road Department, certificate of Oil India Limited. Now, my lords, the personal hearing. Following the principles of natural justice, the noticee was granted personal hearing on so and so, so and so, so and so, but the noticee failed to attend the hearing on the scheduled dates. My lord, this period was during the COVID-19 pandemic. Thereafter, my lord, with the joining of the new adjudicating authority, the noticee has been granted
How can it be? 5/12/19 was not COVID.
from 20.
COVID started only in March 2020. March 2020 and also end of March.
Yes, my lord.
In fact, I remember in December 2019, I had even gone to Bangkok. Thailand, come back. And in January of 2020, I was in Arunachal. And it was only in end of March that, so you were absent.
My lords. With the joining of the new my lords, we were present subsequently. With the joining of the new adjudicating authority, the noticee has been granted another personal hearing in virtual mode on 29/1/2021. As the personal hearing could not be held, another personal hearing was granted on 15/2/21. The noticee, Shri Numal Saikia, and his accountant, Shri Manoj Deka, attended the personal hearing fixed on 15/2/2021 in virtual mode, and the following has been recorded, which is reproduced below. They have explained that all the works is related to government department, then to construction, all the work is exempt. They said that related documents have already been submitted to the department. Due to COVID-19 pandemic situations prevailing in the country, this office was functioning with minimum staff strength. So this case could not be taken up for adjudication in time. As such, the noticee has been given 2 more opportunities to present their case in the form of personal hearing in virtual mode on so and so date. But the noticee failed to avail the same. But my lord, notwithstanding that, we have given our work orders. My lord will find from page number 38. The principal commissioner has discussed for each financial year, each work order that we had submitted, but without asserting as to what kind of activity did we.
Anyway, okay. Now, basically, the thing is this. Your show cause notice was only with respect to 26 AS.
My lord.
Now, 26 AS cannot be the basis for claiming service tax in terms of the judgment of the Supreme Court in that Shri Ganesh.
My lord, this is a seaside judgment.
Huh?
This is seaside judgment, my lord.
No. This is,
Sankeshwari Enterprises seaside judgment, but then, my lord, this has been discussing case law from 2007.
what does the Supreme Court say?
Supreme Court, my lord, has directly not said anything, but my lord, there is a case of the Kerala High Court. Madras High Court, my lord.
What does it say?
Madras High Court. My lord, there is a cross finding. Here, my lord, in this case, income tax authorities had assessed demand based on show cause notice issued by the service tax authorities. The Madras High Court, relying on a judgment made by the Supreme Court, has said that both acts are different tax, and the basis of one notice cannot be the basis of demand for the other notice.
Definitely. Yeah. Where is the Supreme Court case?
That is DPA.
Huh?
DPA. On the second point, whether clarification.
What's the first point with regard to
Lordship, as per my,
can service tax be levied on the basis of the turnover recorded in the 26 AS?
Lordship, there is no direct judgment of any High Court as well as Honorable Supreme Court in
Correct,
this.
but
point.
this is you're the department, no?
No, Lordship, in another case,
Department.
Lordship, there is
High
no
Court judgment is there, my lord.
there is no judgment of High Court as well as.
Do you say that the seaside judgment is wrong?
No, Lordship, I am not making my submission. I submission that our
We have got to go either way. You cannot say that I am in the middle.
No, Lordship, here the substantial question of law which I have framed. Lordship, there is the educating authority has not relied on 26 years only. There is other finding is also there.
Mr. Counsel, one wrong is enough. It doesn't mean that if there are 20 wrongs, all 20 wrongs have to be.
No, Lordship.
If there is one wrong is enough. The simple question that this court is asking you is whether service tax can be levied on the basis of the
26 years.
26
No.
years.
In my simple submission, no. It
No,
can-
if it's not,
Yes.
then we set it aside. We allow you to have a inquiry made. You do the inquiry, and then you can give you can go on with
No,
the show cause notice submit a fresh show cause notice.
No, Lordship, it is, I'm not diverting from my submission, Lordship. Lordship is to see the adjudicating authority. So order, whether it has been based on only 26 years. Lordship.
No, so that is what we're asking you.
Look, it
Is this in this case the show cause notice was with regard to what document?
Lordship, please to see. Yeah, the basis was 26 years, but Lordship discussion was there.
Discussion might be anything. The question is when when you put to notice somebody, you have got to specifically state what is the parameters under which you are going to discuss the issue and what he has got to answer. You cannot say that please answer only with regard to 26A and talk about something else.
I got Lordship.
Yes, you see, say in a departmental proceeding, if a show cause notice is issued with regard to a memorandum of charge regarding someone being drunk, you cannot convict him or find him guilty.
Yes,
Charge of being unlawfully absent.
correct, Lordship.
So, same here.
Here, Lordship, we have received the information from Income Tax Department, but the notice was issued after making investigation and as well as
Then
26.
it's that.
Lordship may come to page 24. Paragraph 16.
Yes.
Lordship, then provision of has been quoted. Then next page, scrutiny of the availability of documents.
Yes.
Paragraph 17.
Yes.
Scrutiny of the various records, namely Form 26 Income Tax and ST3
Yes.
returns reveals the following points. Paragraph page 25, paragraph 17 laws.
Yes.
Then A, on scrutiny of Form 26 as for the period from so and so, it appears that the noticee had provided service to Deputy Commissioner so and so. Then B, the category of service provided by the noticee to the above mentioned service recipient is not ascertainable, as the noticee did not provide any document. He was time and again requested to submit the details of the various amount received till June 2017, but failed to submit any detail. So the amount received under Section 194C during the financial year 17-18 is being taken as a receipt under Section 194C of the Income Tax Act up to June 2017. Then paragraph 6, the noticee did not provide month-wise breakup from the month of 1st April 2017 to 30th June 2017. So the gross receipt of financial year 2017 has been presumed to be that up to June 13th, 2017. 1st April 2017 to so. The next paragraph, the noticee filed nil ST return, ST3 return for the period from 2014 to 2016. Then the noticee did not disclose gross receipt from the various service receipt of ST3 return filed in the financial year 2014. So my humble submission before Lordship that not only Form 26, other documents also taken into consideration while issuing those.
Yeah. What about
मी- तुम्ही कोई बात कर
No, one thing is that he did not provide this, but
So Lordship, my humble submission is that not only the data received from the income tax was considered, some other documents were also considered before issuing demand notice. And he was again, time and again asked to submit documents, but he failed to submit. That has been,
that is you see, one thing is that you also did not submit the invoices. You were supposed to submit, you kept on delaying the matter, you did not submit.
My lord, that is there. That is on record, but my lord, we did it before the CSTAT.
Huh?
Before the CSTAT, we did submit all
Yeah.
the documents.
So where does it say that you can submit this before the?
My lord, may kindly have the Kankeshwari judgment. My lord, at page 5.10, sorry, para 5.10,
Yes,
page 18.
yes,
We observe, my lords have it.
yes, yes.
We observe that it is held in a canton of cases that tribunal being a final fact-finding authority can admit any fresh evidence and argument. The issue was considered by the Honorable Apex Court, three judges bench in the case of National Thermal Power Company Limited versus Commissioner of Income Tax in 1998, which is to the effect that tribunal has jurisdiction to examine question of law which arises from facts.
That is always there.
And my lords, no, my lords, they for the first time also documents can be introduced before the CSTAT because the CSTAT is the highest fact-finding
You
body.
did not give them the opportunity to decide because you did not give them the documents. So they had to pass the orders on whatever documents they had on the basis of
So,
whatever.
my lord,
documents.
my lord, in my humble submission, my lord, what the Honorable CSTAT Calcutta has held is that the initial burden is on them to discharge. They cannot ask us for documents. They will have to make a proper,
Take
credible
for
inquiry.
documents because you did the look. You have done the work, my lord. Now for them to take a decision as to whether you are evading service tax or not, they need all the documents. You are not submitting. You are supposed to
My
submit.
lord, they did submit our ST3
You
returns.
cannot say that. You cannot say that.
So that is
Because I did not submit, am I the right?
that is the whole purpose of introducing this pre-show cause notice consultation. That was the whole purpose, which they failed to issue.
I think best thing is, Mr. Kyal, I think prima facie, I think maybe we should start again afresh.
My lord, but then
The time of because now everything is in the open, invoice is there. I think because of 21, no more show cause notices, pre-show cause notice not required. But this can go.
What's another thing while on the submission of our learned friend, when he is claiming exemption, it is his duty to prove. In that effect, Lordship, I want to place one judgment of paragraph 16. Day before yesterday, that question came before this honorable court and this honorable court answered on the basis of one of the Supreme Court judgment, paragraph 16 of that judgment.
Yes, paragraph 15 of the judgment.
Paragraph 16, Lordship. 6477. Lordship, we come to paragraph 17, the 16. Very good.
Yes.
This court further finds that it is also pertinent to take note that judgment of Honorable Supreme Court in case of Motiram Tolaram versus so and so, wherein the Honorable Supreme Court has categorically observed that in order to claim exemption, the SSC has also to place the necessary materials before the competent authority, which would entitle the SSC to benefit of such exemption. Paragraph 9, then paragraph 9 has been quoted. When
That is also there. He has also got to place.
not
But then he's also correct. You also did not issue the pre-show cause notice in terms of the notification that was in force at that time.
Lordship, to that effect, I am also supported by Supreme Court judgment in BBF.
Where is that?
Yes, Lordship. Paragraph 13.4. The heading is case law respectively clarificatory note.
Yes, in Zile Singh.
Lordship, in the case of Gile Singh, it is observed that the presumption and against retrospective operation is not applicable to regulatory statute. In determining therefore, the nature of the act, regard must be had to be substance rather than to form. If a new act is to explain and order supply of various omissions or the clear up doubts of the meaning of the previous act, it is well settled that if a statute is purity or merely declaratory or previous law retrospective operation is generally intended, an amending act may be purely declaratory to a clear and meaning of so and so.
It has got nothing to do with this.
No, Lordship, my submission before that, Lordship,
You
that
give him also a copy.
then
Mr. S.
a clarificatory amendment, no, Lordship,
my
last
lord,
line.
I will make one submission very candidly, my lord. Perhaps, my lord, because in the clause 5 itself, there is of the 21 of the 17 notification. Notification to 27.
Then last line of that paragraph is Lordship is very important.
My lord, if
A clarificatory
lord-
amendment to this nature will have retroactive effect.
Yeah, that-
my lord, even assuming that that party is applicable, but where is fraud? Where is the element of fraud, my lord? Fraud will only be there when there is concealment or concealment of information. Section 17 of the Contract Act is very clear, my lord.
The thing is that you see, out here, the principal commissioner had already taken a decision prior to your 2021 November notification coming into effect. So where is the question of going back?
No, Lordship,
So in that way, all the other cases where pre-show cause notice may not have been issued 10 years back or 20 years back or 30 years back, that will be rendered useless.
Lordship, in BBF, the question was whether the any clarificatory will be.
This is not a statute, this is a notification.
No, Lordship,
Pure and simple
in
notification.
that case also, Lordship,
Out
notification.
here, there is no retrospective operation of the notification.
Lordship, here, since BBF, Lordship.
See, one thing is very clear. If the decision of the authority had not been taken, then maybe we could have said, okay. But since the authority has already taken a decision, it has closed that chapter. That chapter is a closed chapter now.
Lordship, what happened in case of BBF, what happened, Lordship, notification was issued by the central government clarifying the early notification. Then notification was challenged before this honorable
This is
court.
not a clarification, Mr. Counsel. This is a new thing that has been added.
No, Lordship, may please to see subject clarification in respect of master circular, Lord. That's why I'm making my submission.
Clarification in respect of
Master circular.
circulation number.
Son.
See,
That's why I'm making this submission. Lordship.
I could do that.
maybe, but this clarification notification had been issued after the
Yes.
principal commission.
Yes, it is.
So it does not affect.
But Lordship, in BBS, Lordship, this.
Maybe VVS, maybe. You can go again to Supreme Court and clarify that.
No, Lordship, this is my humble submission. Whether Lordship will accept or not.
Submission is we're not accepting.
No, that is the Lordship. I
That-
can make only my
That's
submission.
all.
My lords, may I make a very small submission? If my lords are planning to revert it back,
Yes.
my lord is going to be a futile exercise. I tell you the reason, my lords, why. Because my lords, we have already provided all the documents before the honorable sestat. Neither before the sestat, even in this memo of appeal, my lord, they have not pointed out one category, one bill which is not.
No, you see, the decision of his staff is not on the merits of the case.
Yes, my lord, but they
It's
are
not,
also not
it's only on the issue of technicality.
my lord.
So they will go, now they will decide on the issue of, on the merits of the case as to whether your service comes within 12, 8, 13 or 14.
But my lord, for that, they have to object.
They have?
They are not objecting. They have not raised any specific,
Okay, we will start from the time, we will set aside everything. Since they have got everything now, the invoice is there, everything is there with them. They will conduct an exercise within 2 months or within 6 weeks. And if they find that there's been exemption, they'll issue you a notice and then on the merits. That's all. Because
then again, my lord, there is
going to
to
affect.
be another question of law, whether the preventive extended show cause can be done in this case, because my lord, that is pending before the Supreme Court.
Preventive?
The extended period of show cause notice, the extended period of limitation under my lord, section 73 of the Finance Act,
What?
whether that can be extended for issuing a show cause notice,
Ah.
again, whether that period can be extended or not, because there is a period for which show cause notice can be issued. And my lord, if my lord set aside this order of the CSTAT, whether my lord can again give that liberty to them to issue a fresh show cause notice,
Why not? On the issue of the on the issue of the merits of the
then my lords,
not an
then
issue
my
of-
lords may revert it back to the CSTAT,
revert it back to the system.
my lord.
Let them take a decision. है ना? Okay. है ना? Right. I heard Mr. S.C. Leonard counsel for the appellant. and Mr. S. Mitra, learned counsel for the respondent. Mr. S.C.K. learned counsel for the appellant submits that the impugned final order number 75470/2022. Oh, be lucky. Dated 11/8/2022. You're very lucky. Long order. Passed in service tax appeal number 75969/2021. By the Customs, Excise and Service Tax Appellate Tribunal, bracket C stat, by close Kolkata, should be set aside. The issue pertains to the appellant's decision to charge service tax on the works done by the respondent under various government authorities such as the PWD, Airport Authority of India, Indian Railways, etc. for the period from 2014-15 to 2017-18. Next paragraph. The facts of the case in brief is that a show cause notice dated 21/10/2019, a demand come show cause notice dated 21/10/2019 had been issued to the respondent by the appellant for payment of service tax. Huh? For payment of service tax under the
Finance Act 1994.
Finance Act 1994. Under Section 67 of the Finance Act
No.
1994. By basing its claim under the returns provided in Form 26 AS of the Income Tax Act for the period 2013-14 to 2017-18. The respondent submitted his reply. Where is the reply?
Before the my lord,
Before, with regard to this demand come show cause notice, you did not submit.
my lord, we said that's carrying the observation of the principal commissioner, what all documents we submitted. I've not annexed it.
13/12/2000.
The respondent submitted his reply to the principal commissioner, Central Goods and Services Tax Department. Which did not include the invoices of the work done by the respondent. Except for work orders that had been issued to the respondent and other documents. The Principal Commissioner CGST Dibrugarh thereafter issued Order dated 22/10/2021. Where is the relevant portion? Directing payment of service tax from the response amounting to rupees 6,39,09,190. The respondent being aggrieved by the said order passed by the principal commission file service tax appeal number 75969 of 2021 before SIST at Kolkata. The learned tribunal. Tribunal?
Tribunal.
Yes, tribunal. Thereafter, dispose of the said appeal by final order number 75470/2022 dated 11/8/2022 by holding that the by holding that the service tax could not be levied upon the respondent without any pre-show cause notice being issued
My lord, that was the second.
by on the basis of the returns provided in Form 26A. Correct.
No, my lord. My lord, not returns, my lord, from 26 year statements.
From the
Mere gleaning of
from the contents of it, not the returns, from the contents of Form 26A. Filed before the income tax authority. The second ground for setting aside the order dated 22/10/2021 passed by the Principal Commissioner CGST Dibrugarh by SISTAT by the learned tribunal was on the ground that pre-show cause notice had not been issued to the respondent prior to the issuance of the show cause notice dated 21/10/2019. In terms of the okay. Here we go. In terms of the notification, the master circular dated 10/3/2007. Next one. The Principal Commissioner CGST has accordingly filed the present appeal challenging the decision of the learned system by proposing three substantial questions of law which are as follows.
My lord, in fact, the substantial question of law, which was originally in the memo of appeal, my lord will find at page 15.
Page 15.
Yes, my lord. So, my lord, once a substantial question of law has been submitted in the appeal memo, whether subsequently another question, substantial question of law can be proposed.
Anyway, we'll just put this and we'll decide how to do it.
Only lordship, with this effect, lordship, there is a provision in the act also.
Huh?
There is a provision we can submit another substantial question of law for consideration of a lordship. That is also here.
This 15 is not a substantial question.
Lordship, in memo of lordship, I do admit all the substantial laws which has been proposed to be framed. There,
Which provision are you talking about?
lordship. Four,
Four. Section 4.
proviso. Section 35, 4, proviso.
35/4.
Lordship. 35G. Provided that nothing in this section, subsection shall be deemed to take away or abridge the power of the court to hear or reason to be recorded, the appeal on any other substantive condition of law.
And how does it matter?
Yes, not formulated by it. It is satisfied that the question involves a question. The court has power, Lord.
What was the fifth for us? Right. I will just ask for the 1, 2, 3. Okay. In terms of section 35G of the Central Excise Act, 1944. In the case of uh, Kankeshwari Enterprise versus Commission of Central Excise and Service Tax, Bhavnagar, reported in 2023, 9 syntax 77, bracket TRI full stop dash AH MD bracket close. Decided by the learned Sistat West Zonal Bench, Ahmedabad, bracket code number Roman 3 on 28/6/23. It has been stated in, it has been held that without conducting any independent inquiry on investigation, the demand of service tax cannot be sustained only on the basis of 26 AS data provided by the income tax authorities to the central excise officials at Bhavnagar. Service tax demand cannot be raised on the basis of assessment made by the income tax authority. Income tax and service tax are two different and separate independent special sinful acts, and their provisions operate in two different and independent fields. By relying only on 26 AS data of the Income Tax Act, demand of service tax cannot be made. The data provided by the income tax authorities simply show the details of income received from the sale of services and service tax paid thereon. However, in income tax returns, no further details of exemptions availed on services requires to be declared. Hence, there may be mismatch in the data of income tax vis-a-vis service tax returns filed, depending on the facts of each. This is, I have put it in red, huh, with it. In para 5.8 and 5.6, no, 5. All is there. Next. The learned tribunal had also held in the above case that whether with regard to that pre-show notice,
Please show cause notice, my lord, nothing, nothing in this judgment.
And also held that the revenue department could not argue a case which was not made out in the SCM, in the show cause notice. And the adjudicating authority could not travel beyond the show cause notice. As such, in view of the decision of the learned tribunal in Sri Kankeshwari Enterprise Supra, which has not been challenged by the appellate, no, which the appellate's counsel submits that it does not have any issue with, comma, the levy of service tax on the respondent by the appellant
My lord, may I rely on one more case of the.
on the basis of the 26 years data is palpably not permissible. Yes,
May I rely on one more case, my lord, of the Honorable Gujarat High Court?
yes.
Nimesh Bhai today. Nimesh Bhai, Bhuvan Bhai Patel. Similar issue, my lord, Gujarat High Court has also said the same thing.
Which para?
My lord, para 14, 15, 16.
Similar has been the view expressed by the division bench of the Gujarat High Court in the case of Nimesh Bhai Gunvan Bhai Patel versus Union of India, reported in 2024-25 syntax 122 bracket Gujarat. That's all. Similar view.
Similar.
Next. Next. With respect to whether a pre-show cause notice was a necessity prior to the proceedings for levy of service tax being demanded from the respondents, we would have to see the we'd have to see the we'd have to consider para. Where is that?
5 blocks.
Para 5.0 of the master circular number 105P/2/2017 CX dated 10/3/2017, which states as follows. 5.0. I think that's the only 5.0.
Yes, my lord. In 2017, that's the only clause.
While no, uh, while para 5.0 of the master circular dated 10/3/2017 has made it mandatory for a pre-show cause notice to be issued for no, in respect of cases involving demands of service tax. Pre-show cause notice consultation is mandatory in cases involving demands of service tax above 50 lakh, comma, a subsequent note, circular number 1079/03/2021 issued by the Government of India, Ministry of Finance, Department of Revenue, Central Board of Indirect Taxes and Customs, provides that, no, has clarified para 5.0 of the Master Circular dated 10/3/2017 by stating that pre-show cause notice consultation shall not be mandatory for those cases booked under the Central Excise Act 1994 or Chapter 5 of the Finance Act 1994. Central Excise 44 and Finance Act 1994. For recovery of duties or taxes not levied or paid or short levied or short paid or erroneously refunded by reason of, it is here A, B, C, D, E. Yeah. But out here, this show cause notice does not talk of this.
No, my lord.
In the present case, the show cause notice was issued to the respondent on 21/10/2019, and the issue of payment of service tax had been finalized by the Principal Commissioner CGST Dibrugarh by order dated 22/10/2021. That is prior to the subsequent circular dated 11/11/2020. Further, there is nothing in the show cause notice dated 21/10/2019 to show that the service tax levied, thought to be levied upon the respondent was due to fraud, collusion, willful misstatement, suppression of facts, or contravention of any of the provision of the Central Excise Act 1944 or the Finance Act 1990 or the rules made thereof. In that view of the matter, we are of the view that the show cause notice dated 21/10/2019 and the subsequent order dated 22/10/2021 passed by the Principal Commissioner CGST Dibrugarh was not proper. In view of the above reasons, in view of the above reasons, we are of the view that the entire issue as on date, having been decided solely on the issue of technicality, inasmuch as the invoices had been submitted to the learned system only by the respondent, the matter should be remanded back to the learned.
My lord is setting aside the ordinary also.
Naturally.
Then, my lord, again, it has to be remanded back to the adjudicating
No,
authority.
no, okay, then we have to set it aside.
My lord can set aside the cease tax order and remand the matter. Not the order in origin, my lord.
No, no, we are only setting aside the system.
My lord.
No. What are you saying? To the learned system, Kolkata, for a redetermination of the merits of the case. Without going into the issue of whether, without going into the issue of whether show cause notice consultation or going into whether the 26 AS data only could be the reason, could be a ground for issuance of a show cause notice. All the work orders and invoices and all other documents having already been sent to the learned system, or the learned system shall take a fresh decision after hearing, after giving an opportunity of hearing to both the parties on the merits of the.
But my lord is setting a precedent, my lord, which is unlike any other, which has been contrary to the other rulings of the High Court. Because my lord, this pre-show cause notice consultation, there have been number of cases where it has been held to be a mandatory thing.
Then we'll have to set aside everything. We'll ask from the, we can do that also. We can, if you want, we can do it from the time from pre-show cause notice. We're just trying to make out a case
Not,
where both of y'all don't have to go through the entire process again. You want to go through the entire process, we have got no problem. We'll record it. Want to go?
No.
Okay. This decision has been made to this decision directing the learned fiscal take a decision on the matter on merits is being made with the consent of the parties.
not.
My lord, make for one observation, my lord. The CSTAT has to decide the issue and not adjudicate it to the all.
Merits,
my lord,
merits.
And no, my lord, not delegate it to the authorities below.
And without relegating
My lord.
that
observation.
Let them do it.
My lord, small observation. Otherwise, my lord, they'll again remand it back to the adjudicating.
Without relegating the said issue. Without relegating the be decided on merits to the authority.
My lord.
Okay.
Not much.
The consequently, the impugned order, final order number 75470/2022 dated 11/8/2022, passed in service tax appeal number 75969/2021, passed by the learned system of.
Not obliged, my lord.
The appeal is a.
Two have received the report, madam, as regards service.
Okay. So response number 2 has been served.
Yes, your lordship. To be-
My lord, TCR received, my lord, and
This for the response number 2.
She is appearing.
You have been made the legal aid counsel.
Yes. No.
Oh, you have been engaged.
Yes.
Okay.
so my
Uh,
TCR received, my lord, and the estate has also-
registry to prepare the paper book has
my lord, I have a prayer for bail, my lord.
been made.
IA is there.
1 minute, one at a time. Then, Miss Madam,
तुम्हारा नाम
SS Saikya appears for the response number 3. Have you filed Vakalandama? Submit the share submitted Vakalandama. Leaves the matter for hearing. When?
paper, lordship, paper book has to be prepared.
I know. It's the
Well,
matter. I've always said. It's not heard.
2025 matter.
So when do you want? How does it matter? In usual.
Yes, madam.
In usual course. Then in the IA. Madam,
We have filed an objection.
Objection
can you
already.
hear? Okay,
Yes.
hear.
Thank you, madam.
My lord, may
What is the, you're in love?
Yes, my lord.
Up to rupees 20. Start the chat. Chat I will assess it.
Come to PW1, page 10.
Yes, yes, ma'am. I will assess. Well, we'll come to the, before coming to the PW, I'll request your lordship to look into the postmortem report first. Just a moment. So, may I not plan. Who is Krishman? Morning,
96.
yes, ma'am. मेरा पोस्टमार्टम रिपोर्ट में मार्क करके रख पोस्टमार्टम रिपोर्ट में पिक्चर ड्रॉ करके रखा था सुबह में दिखा
Yes.
Page 96, your lordship has seen. Now your lordship will find at page 96, the person age is 25 years. Then your lordship will skip to the next page.
Yes.
Your lordship will see the condition of subjects, tau, emancipated, decomposed, etc. Why I'm trying to refer to the postmortem report first, because when I will be taking your lordship to the deposition of the witnesses, your lordship will see that it was frontal attack, and some have said multiple injuries. But if your lordship looks into the postmortem report, your lordship will find that the injury is from back. Either why I'm trying to show the injuries in from the back, because if it does not normally, if the ocular evidence does not tally with the medical evidence, normally your lordship will give more importance to the ocular evidence. But the cases where the witnesses are all related to the disease, and if the postmortem report gives a description of the injury or the nature of the injury, which is not possible for the ocular, which does not at all tally with the medical evidence, then your lordship will see how it has to be appreciated. Now here your lordship will see the first the external appearance. Male dead body of average build, dark brown complexion with surgical pad and bandages in front of abdomen. Eyes and mouth closed, rigor mortis fully established, and so, anus, penis, and scrotum healthy, surgical drainage catheter in both sides of abdomen. Then your lordship will see the wound's position and character. This is surgically made stitch on, first one, with approx margin. It's not a post machine, it's approx margin. Size 20 centimeter into 2 centimeter. That means it is a narrow wound tract. Then the cavity means the body deep in front of abdomen in midline, and a long in front of abdomen in midline means it is a long narrow tract. Now your lordship will find again the second one, stab wound, surgically made of size 3 centimeter into 1.7 centimeter cavity, deep in both limbar area in front of abdomen with rubber catheter in situ. Then your lordship will find stitch puncture wound of child so-and-so cavity deep in back of abdomen. This is what I was trying. Third, I'll come to the second injury later. Stitched puncture wound of size 3.5 centimeter into 5 centimeter cavity deep
in back of abdomen, 3 centimeter above iliac, it is second chest, into 13 centimeter to right of midline. The wound is stacked from the point of injury, iliac vein mesentery, and up to the hepatic fracture of the large vein. So now your lordship will see the opinion. At page 101. Death was due to hemorrhage and shock as a result of stab injury as described in injury number 3. That means the back injury, which was antemortem and caused by pointed weapon and homicidal in nature. Reaction is from below upward, front back and front, and from right to left. So I have only to see the stab wound at second, that is surgically of size 3 centimeter into cavity deep in both lumbar, it's not limber, lumbar area front of abdomen with rubber catheter in so and so. Then your lordship will see the right lung, left lung at page 99.
Yes.
Both is healthy, pericardium healthy, heart healthy, vessels healthy. Then your lordship will see the peritoneum.
Yes.
Peritoneum, your lordship will see punctured with scissors. Peritoneum means the front side of the abdominal cavity, punctured with scissor, mesentery, contused, clotted blood present, 750 milliliter paravestibular tissue confused in the right side. Then again, your lordship will find that 5. Small intestine and its contents, contused at places. Contused means by bruised, contain digested food without suspicious smell. So small intestine, there is only an external cut order. Then your lordship will see large intestine and its contents. Contused and required surgically in heptaflexure of large intestine, contain fecal matter and gas. This is again only in case of large intestine. Then liver healthy and plain, spleen healthy, kidneys healthy, left side, contused, bladder. Then your lordship has seen the opinion of the doctor. Now we'll go for the deposition of each of the witness to show your lordship that what the witness have said as to regard how it has occurred, whether it will tally with the medical evidence. I'll come to it again, but now we can go by one the evidence of the witness. Analysis इसको पूरा चमकता है कल पढ़ के अच्छे से बना तो now your lordship will see PW1 at page 10. PW1 is the my lord informant and who is an eyewitness. And he is the brother of the injured eyewitness.
Brother
Of the injured eyewitness. PW4.
injured PW4.
And an uncle of the deceased.
Yes.
Although, my lord, he is an interested witness, but I will know that although being an interested witness, your lordship will see his testimony closely, my lord, because he may not be unreliable, but your lordship will look his evidence closely. Now, your lordship will look into the first what he states in the FIR. FIR, your lordship will find at page 4.
Yes.
An FIR, your lordship will find that it was written by an FIR writer. That's where all the problem starts normally in cases, because there will always be an exaggeration in the FIR. Your lordship will see page 4. I have the honor to state that around 5:30 p.m., that's in the evening, on 27/9/2013, the accused person's name below were hiding near Hassan Ali's house in a pre-planned manner, armed with dagger, dao, spears, and suddenly attacked and severely assaulted my younger brother and my son while they were coming home from Gaspar. Accused Surab Sohan. Sohan, I think it's our accused name is Sobahan, but they are referring him as Sohan. So we have to look into the original in vernacular whether it is Sohan or Soban. Tried to kill Siddiq and Ainuddin, respectively, by stabbing them with dagger and dao. However, hearing the scream, the neighbors came forward and found them still alive but bleeding profusely. The accused person snatched an amount of rupees 30,000 and a mobile handset from the pocket of the injured person. Although it is mentioned in the FIR, but subsequently they did not go with this statement. It is only the people think that if you snatch the mobile or if you say snatch the money, then you can make it more grievous offense. Although the injured persons were later admitted into Duguri Hospital, they are fighting for life. Lodging of the Azahar got delayed as I was busy taking in care of both the injured. I therefore pray to register a case, investigate the matter and the accused persons and send them to jail. Now your lordship will find, so far Surab Ali is concerned, that is accused number 1. He has been convicted under section 323 IPC. He is not before your lordship. Sohan Ali is convicted. So this Sohan or Suban, I will check it with the original vernacular from the record. He is convicted under section 302 IPC. There is the present applicant. And Tahir Ali is acquitted. Then Hassan Ali is acquitted. Then Orjun Bewa is final report submitted again 5, 6 and 7. No, not charge sheet.
So, so only one. Saurabh Ali does it. The Sohan Ali.
Sohan Ali remained so far.
So you are Sohan Ali.
Sohan, I'm Sohan Ali. I'll just check with the record whether this Sohan is Soham or not. Original vernacular, I'll check it during the lunch recess.
Okay. What we do is sit after lunch. And at lunch I've got a single bench. Two of got. Yes, that will take just 3 minutes. It won't take long. After that, we'll continue with it.
We'll come at 2:30, madam.
No. It will take just 5 minutes. Within 5 minutes, I'll finish. Not even 5, 3 minutes. It will not take long.
Monday morning, Monday, Tuesday night.
We'll do this.
You'll also kindly take it at 2:30, madam. I have some, I'll just finish it up and rush here.
No, she has also got, my sister also has got a new bench. So we have to separate.
So. Your lordship can keep it parted and fix it on Wednesday next month.
Disposal of no more agendas. That is the second time. We can- Let me finish it.
By 2:30, I'll come. Just I have one matter, I'll finish.
Where? In whose court?
Well,
In whose court?
I have other matters. Fixed.
Yeah, I know. In whose court are you going?
There are 2, 3 matters. I'll just finish up. At 2:30, I'll come. Your lordship will take up some other matters. I'll come at 2:30. I think
We have got no more division bench.
One more matter.
one more matter is there.
So only this matter is there.
Another matter.
No, we cannot take up open.
Actually, I-
We'll take it to 30.
Anytime, I will-
Okay, 2:30.
Yes.
Idle bench matter? No.
Please, my lords. So item number one.
Item number one. Yes, what about it?
Yes. Item number one for Aizawl bench matter, my lords.
Just a minute, just a minute.
Sorry, my lord. I'm actually sorry.
I'll just do the idle bench.
Item number one, contempt case one person.
Yes?
To this
Yes,
contempt.
yes, I know. What about it? This week, we'll just do item.
Sorry.
Okay, right. Yeah, Mr. Bampa Paliwal, na?
Yes,
Okay,
please.
you just take yesterday's order. Where is yesterday's order? Where is yesterday's order?
My lords, it was dictated in the court. It is in fact available on the website as well.
It is available on the website.
Yes,
It
my
is
lord.
not here. What is happening? Okay, anyway. Basically, so how much cost will you pay?
My lords, we are in your lordship's hand, whatever your lordship says.
Why did you not take any action? Why
My
did
lords,
you inform the court? You were there, you were well aware of the pendency of the cross appeal.
my lords, this is actually an interdepartmental issue. We had addressed it to the Aizawl office. Since the information, it appears that Aizawl office did not receive the information from Kolasib office. This is the real factum that I am informing, my lords. In any event wherein
I
your
doubt.
lordship,
You all will be doing everything. You were waiting for which, whether, in which case you'll get the better offer, the better decision.
my lords, that was not the intent. I can only make that much submission before my lord.
Actually, that is the only submission you can make. Yesterday's order, huh? Your para one, para one heard, Mr.
Shubham Paliwal.
Pam Paliwal, let it pass before the appellant. No one appears for the respondent. Then number two, you take number two out here, then number three also. Number four also. Number five also. Then number six. The judgment and order taken. 3/2/26 passed by the additional district session that policy has been produced. And has been brought to my notice. And the perusal of the same shows that the impugned arbitral award dated 23/9/2024 passed in arbitration number NH-306/KLB/5/ARB-323 has been he has not set aside the order.
He set aside the award.
Where is the setting?
Well, it's para 25.
No, it's
24
only
to
remanded
25.
back. The order has not been set aside.
That's I think the frame of it. Para 24 and 25 would of course obviously read in that manner. Milad.
No,
It's
so he's remanded it back, but he's not set aside the order.
I see what's falling from your lordship's. But a reconsideration would obviously, set aside the order as is. Because the order, the award,
Maybe, but then unless you set aside, how can it be? So, you withdraw, you go to the same court. You ask them to pass the order.
since this is a 34 court, the jurisdiction has now gone.
Oh, that's
That
what,
court is functus officio now.
then, what to do?
What I was beseeching, my lords, was to allow the withdrawal with liberty to appear before the arbitral tribunal and take our recourse as per law. That's the only.
I will allow you to withdraw because of this. What am I?
Yes, my lords. We can then participate before the tribunal, my lords. Before the sole appeal.
That shows that the matter has been remanded back to the sole arbitrator to reconsider the matter. However, it is noticed that the arbitral award dated 23/9/23 in arbitration number NH-306-KLB-5 ARB 2020 has not been reconciled. As the appellant has paid for $2 a case due to the above development, the prayer is allowed. The present appeal is accordingly dismissed on withdrawal.
My lords will just leave me the liberty to appear before the
You do
tribunal.
whatever, you do whatever. I'm not. When we write in the main I, in the order, the main appeal, the I is of accordingly different.
Very well. I'm
Huh?
grateful for the indulgence given, my lords.
So it's surprising that the first appellate court did not dispose of the appeal and the cross appeal at the same time, and had passed two differing orders in the appeal and which could have been taken care of if the same had been decided, same had been disposed of by a common order. Not that. Okay, next.
So grateful.
Ah. Correct, we'll do that. We'll do that single bit. Yes.
May I please announce? My lord, this is the contempt case, it is a clear violation of the judgment and order dated 38/2022, passed by this honorable in WPC number 702/2018. My lord, paragraph 20. Now, what is just before, and as per the last order, my lord, they have violated the order because within the outer limit of 3 months, they should have completed a second opportunity was given to make an inquiry regarding correction of my date of birth. Page, minor page 28, para 20. May I read, madam? Para 20. It is cost of repetition. The case herein is that the employer of the employee, that is the petitioner, has sought to refix the date of birth of the petitioner by changing the same from 2357, already recorded in the service book of the petitioner a long year earlier, to 2/1/1955. As has been observed above, the state has the authority and the power to refix the date of birth of a government employee, even though a different date was accepted by the government at the time of appointment.
Yes.
But the
Lordship, we have complied this order, Lordship. There is inquiry was conducted and inquiry report has been submitted, Lordship.
Where is it?
I filed my affidavit, Lordship. Lordship may kindly see my affidavit page.
Oh, you filed?
I have filed my affidavit, enclosing the inquiry report, Lordship.
That inquiry report after more than 1 year.
Maybe, but he has done it. You see, it has to.
Now, Lordship, only thing is he is on delay. He is on delay. Why delay is occurred in?
No, my learned friend has, I want to draw the attention of this honorable court. Here is a specific time period.
Maybe
But the honorable court, this honorable court on 19/1/2023 asked him why you have not conducted the inquiry.
now it has been done.
19/1.
Now it has been done.
My friend is at liberty to
They
check
have,
the inquiry
they
report,
have,
Lordship.
they have asked unconditional apology before this honorable.
Maybe. End of the
They
matter.
could not conduct.
End of the matter, Lordship. End of the matter.
End of the matter, my lord. Therefore, as per that judgment, my pensionary benefit only gratuity amount and the
Where is this? Where is your affidavit?
Lordship, my affidavit, Lordship, page 44, Lordship. Page 43 from onwards, Lordship. Running page, Lordship.
13?
43. Page 48 is the inquiry report, Lordship.
Okay, so what is to be done now?
Lordship, in fact, he is trying to show that, Lordship, there is a delay in complying the order.
But that's a different thing.
This,
That has been complied with.
Lordship, comply to it. Comply to it.
My lord, they have not complied with it. They, lordship, kindly see, very important point to recall. I want to,
Hold the order, please.
Order is page, Lordship, 28.
Right.
Yes. Page, paragraph 20, Lordship. Page 28.
kindly see, my lord. In the middle person.
So. So there is no question of any payment or anything to be done.
Lordship, Lordship, may kindly see page 50 now, Lordship. Affidavit, Lordship.
No,
My
no,
affidavit.
page 15.
50. The consequential order of the, after the inquiry report, Lordship. In pursuance of para 20 of the Honorable High Court's judgment order dated so and so, the authorities of the Irrigation Department constituted an inquiry committee on so and so dated 29/23 to make an inquiry regarding the actual date of birth of Sri Kovichandra Talukdar, retired Pesa. Accordingly, the inquiry committee asked Sri Kovichandra Talukdar, retired Pesa, to take part in the inquiry process, but he refused the same by letter dated so and so. Thereafter, the inquiry committee, after thorough inquiry, submitted its inquiry report dated 3/11/23, whereby the actual date of birth of Sri Kovichandra Talukdar, retired Pesar, was established as 119.
This order just.
Yes,
Yeah.
yes. He is-
But my learned friend is misleading your honorable.
Tell me how?
Why misleading, my lord? Because, my lord, it is in compliance with the last order, my lord, honorable court has observed that it must be completed within the outer limit of 3 months.
So if it is,
Otherwise, my lord, otherwise they'll have to.
if it is not completed, then what happens?
My lord, if they not, they are not willing to comply within the outer limit of 3 months, they will have to pay my pensionary benefit within 2 months from the date of judgment. That is the case, my lord.
Where does it say that?
Paragraph 20, my lord. Paragraph 20, kindly see, my lord. It's a very interesting point. How I am suffering for last 9 years. I have been deprived from my legitimate right to receive my provisional pension. I'm a very simple.
Oh, no.
Yes,
There
Lord,
is no
kindly see.
subjection, Lord.
Kindly see, in the middle portion, Lord, I want to draw the attention of this honorable court. If a decision is taken to proceed with the inquiry, then the state respondents are at liberty to proceed with the inquiry from the stage where the infraction had occurred and complete the inquiry by following the mandatory procedure laid down under the rules, but the same must be completed within a period of 3 months from today. From today. Again, Lord, considering the fact that the dispute obtained in the year 2016, any decision in relation to recovery on the ground of alias overstay service by the petitioner will abide by the findings and decision arrived at such inquiry with regard to the date of the birth of the petitioner. it is provided further that in the event the state respondents take a decision that there would be no further inquiry, then they should process the matter of pension and other retirement benefits of the petitioner by taking the petitioner date of birth as 2357. That was correct at
Then
28
you
years
filed
back.
it. Heard, Mr.
2357, my lord. Therefore, my lord, on the basis of the 250, my pension is only gratuity amount I am entitled to receive and monthly regular pension.
Just give it also for the petition. Also heard, Mr. And then the letters.
N Upadhyay, Lordship.
Then litigation.
Lordship.
Query for the response number 1 to 4.
Yes.
Mr. C. Barwa, let counsel appear for the response number 5. The petition has no, the contempt petition has been filed alleging willful, deliberate disobedience of the judgment and order dated 30/08/22, passed in 57/02/2008. By which this court had set aside the impugned order dated 8/12/2016, along with the decision to recover the amount of rupees 7,41,34 towards excess drawl of pay and allowance for the period of alleged overstay in service from 1/2/2015 to 30/11/2000.
Already it is set aside by this order.
That's what I said.
Regarding.
It was further directed that in the event the government desired to refix the date of the petition, date of birth of the petition, then the same should be done by conducting a proper inquiry. It should be completed within a period of 3 months from the date of the judgment and order. In the event no such inquiry was conducted, then the pension and other retirement benefits of the petitioner should be finalized, and the entire due should be disbursed to the petition within a period of 2 months from the date of the judgment. The case of the petitioner now is that the inquiry conducted by the respondent, which concluded that the claim of the petitioner could not be substantiated by any supporting document, was not within the specific time limit set in the order dated 30/08/22, passed in WPC 702/2018. In fact, there was a delay of 1 year, 3 months in completing the inquiry, which has not been. In completing the inquiry. I have heard the counsel for the parties. The relevant portion of the order, no, the para 8, page 20,
28. Paragraph 20.
28 page number.
para 20
Yes, madam. Page number 28. 28.
and 20, the para 20 and 21 of the order dated 30/8/22, passed in WPC 702/2018 states the inquiry made by the said order, in person to the said order, though belated, has come to a finding that The date of birth of the petitioner was 1955, 1119. And his date of superannuation was 31/01/2020. The office order dated 31/7/2025, which is made in pursuance to para 20 of the order dated 30/8/2020 in WPC 659/2022. States as follows, page 50, 50. Considering the fact that, though there is a delay in completing the inquiry and coming to a decision, this court finds that the order dated 20 past the WPC has been complied.
My lord, there is a second affidavit today. I filed unconditional apology. That unconditional apology is not counted as a compliance of the order, my lord.
No, the order of 31/7/2025.
My lord, as per order, last order, my lord, they have submitted the affidavit, my lord. They have asked unconditional apology.
Mr. Counsel, they were supposed to do
My
it.
lord, my lord, after 1 year, they have completed the inquiry.
They have done it at least.
I am entitled to benefit. I am get the benefit only as per this judgment, my lord.
Obliged, lordship.
My respectful submission, my lord, at least that will be released, my lord. Otherwise, my on the basis of the 257, the date of birth.
That Mr. Counsel, the order of the order.
Submission only, it will be recorded, my lord. 57. It is recorded here.
Contempt, Mr. Counsel, this is a contempt.
My lord, it is my respectful submission. A person who has been suffering for last 9 years, not a single provisional pension has been paid by them. Now, my lord, why?
In a contempt, you know the law of contempt.
My lord, contempt case already, as per last order, last order 19-1, lordship, can you see? It is very serious matter, my lord, very serious.
Not listening to me, why should I listen to you?
At least, my lord, as per order, only gratuity amount and monthly pension.
I am appealing for response number 1 and 2, my lord. We need some time to file affidavit.
Okay, Miss
Yes,
Counsel for the response number
1 and 2.
is granted.
After 3 weeks, my lord.
3 weeks time to affidavit.
Lordship, a small submission in this matter, your lordship. Lordship, they are taking time. On last occasion, they have said that they have completed the instruction on only last order may be seen, your lordship. For last 2 years, you kindly see the age of the
My lord, in this case,
petitioner.
I am appealing on behalf of my lord,
It's
SMT.
already 58 years, lordship. He has
50
got
done,
promotion, your
done.
lordship.
My lord, in this case, I am appealing on behalf of my lord, SMT 60. He has some difficulty today, my lord.
At
That's
least-
why.
Tell the officer, let him.
My lord,
Only for response number 2,
My
your
lord, we'll take
lordship.
it up then
Response
next week,
number
my
1
lord.
is doing the lordship.
Yes,
Response number
yes,
2 is not.
Just see. The office, the last order passed by this court states that. Which is, let it file the affidavit due to with the adverse. Miss S. Appearing for Mr. SMT Kiski, learned counsel for the response number 1 and 2, submits that.
my lord, SMT 60 has some difficulty today, my lord.
That Mr. SMT Kiski has some difficulty today.
Next week, my
Is the
lord.
matter on Monday? Okay.
Lordship will look into order 21/1/2026. While the other provisionalizations of the service of the respondent number 6
Please,
are in
this-
a set aside. My provisionalization is directly to be considered. Accordingly, SSC considered, but no formal appointment order has been issued till date. Now it has to be complied within 3 months from the date of service of the copy of the order of this honorable court. We have submitted it.
Yes, madam.
My lord, may peruse my lord, my instruction last para, my lord. Upon receive the approval of the my lord. We have already forwarded it to the finance department for
For
control.
last 1.5 years that is going on.
It was my lord earlier place, my lord, but there is some defectors there, my lord.
Again, re-endorse the finance department. Yes.
My lord.
It was again re-endorse.
Because my lord, earlier, my lord, there is some mistake, my lord. They have,
Yes.
there was some
That-
query, my lord.
Okay, let's see. Okay, right. Miss S. Tutia, learned counsel for the respondent number. Submitted letter dated 19 to 26 issued by the Deputy Secretary to the Government of Assam, Department of School Education, which is to the effect that the matter has been re-endorsed to the Finance Department on 10 to 2026. Wide main file number 727330, seeking their concurrence.
My last of the final opportunity has given me. 21/1/2026.
Seeking the concurrence for what?
Well, financial concurrence is mandatory, my lord,
What?
for provincialization, my lord.
Seeking the concurrence, utilization of the service of the petition. The Ms. S. Prithia shall obtain the latest status report with regard to the above by the next day. Please the matter of when?
After 2 weeks, my lord.
Give a date. Then a date.
Hopefully something.
Hopefully.
My lord. For my lord, in this case, we have filed review, my lord.
Well,
This
that-
matter may go after 2 weeks, my lord.
But that review was filed 9/1/2016, so 26, it's yet to be registered. So register will list this case along with the review application. Otherwise, it was filed on 9/1/2026, the review. Its filing number is 316/2026. The state had filed the review. So both these cases may come up together based on.
No, let it be. Right. A revision petition has been filed.
My lord.
Review.
Review petition.
Review.
Is it? Okay, Ms. S. Prithia submits that a review petition has been filed against the order. Website show order dated 10/6/24 in WPC 2601/2020. And the same has been given filing number 316/2026. List this matter along with the said review petition. Yes, madam, what do you want?
The order is complied already, but on the last occasion, the petitioners, they took time to take instructions, but he is not present.
We'll take it up after some, no one appears for the petitioners on form. Miss,
Tinlung. Tinlung, TINLUNG,
counsel for the
NC Hills.
let's see here,
Yes.
submit. Letter dated 15/12/2025 issued by the Principal Secretary, NC Hills Autonomous Council, which is to the effect that the petitioner has been appointed as Khalasi under the Irrigation Department, Dimahasa, as per merit list. He accordingly submits that the order passed in WPC 3689/2024 has been complied with. Correct. The letter dated 15/2025 passed by the Principal Secretary, NC Hills Autonomous Council is made a part of the record and marked as annexed. In view of annexation, the contempt petition is passed over.
Obliged motion.
The matter pertains to fixation of final pension. Lordship will find the relevant order at page 14, the relevant portion.
Yes, we have found respondent.
Respondent number 2, Lordship.
So, who is the main? 7?
No, Lordship, there are only two respondents.
Okay.
I think director
Respondent number 1, Lordship, is the Director, Cultural Affairs. The matter as of now is pending with respondent number 1.
Yes or 2?
Yes, Lordship.
So what about 2? 1, has it been served?
Chip, taken steps, but only respondent 2 has entered appearance. This has gone.
Oh, wait, has received. 1 has written a letter. Yes, what have you got to say?
Also, in our case, audit report is submitted. Audit report is submitted. The main part is also the director will give the.
Okay, right. But the respondent number one has submitted a detailed reply.
Right.
Let's go through it. What was supposed to be done?
Lordship, there was an audit exercise that was supposed to be carried out within 60 days. And on conclusion thereof, 60 days further, my pension was supposed to be finalized,
Was not given,
not given.
right? No one appears for the respondent number one. While Mr.
DCA Boro Lordship.
DJ
Boro.
Boro appears for respondent number two. Petitioner's case is that he has not been given his pension. Office note, however, indicates that the respondent number one has filed a detailed reply on 3/2/2023. List the matter on Monday. On the next week, not Monday. the next week.
Okay.
All right.
Yes, your lordship. Respondent was supposed to file reply.
Yes.
Your lordship, I have not yet received it, so I'll file
Okay, Miss
K. Fukan.
K. Fukan appearing for respondent number 2 and 3.
2 and 3, but 3 is no longer there, your lordship. She has been transferred to Hailakandi.
Appearing for respondent number 2, submit. He needs time to pay instruction and file a report.
Yes, sir. Lordship.
He further submits that respondent number 3 has been transferred
Your
out.
lordship.
Has been transferred out to
Hailakandi.
Hailakandi as
ADC, your lordship.
ADC. This is the matter. After 2 weeks.
Deeply obliged. Obliged, your lordship.
Lordship, in this content matter, it's a non-compliance of the order dated 23/2025. Lordship, on last occasion, the notice was issued, but as per the office note, the AD card has not been done back from the sole respondent. Your Lordship.
You're right. Office note indicates that there is no return of AD card or unserved notice from the respondent. In respect to the notice issued on 8th of 2025, then
Lordship, Lordship, actually similar matter, content matter has been fixed on 25th February. So this matter may be taken along with.
on the prayer of the petitioner's counsel, list the matter on
25th February.
5/2.
Much opposed.
Yes, what is?
Lordship, we had filed a contempt on, as the petitioner was not allotted any work, but however.
Okay, right. As per office note, there is no return of AD card or unserved notice from the respondent number one. In respect of the notice which was issued on 29/1/26. So we have to wait, in 1 month. List the matter after 2 weeks.
2 weeks. Pleasure.
Therefore,
For the respondents, Lordship.
oh, very good. Mr.
AK Ghosh.
A.K. Ghosh appears for the respondent number
Lordship, for the
one, sole
respondent.
for the sole respondent, and submit that.
Lordship, this content may be closed.
And submit that the order dated. And submit that the order dated 2025 passed in WPC 688/2025 has been complied with. While corrigendum number so and so dated 25/1/2026 issued by the Commissioner Panchayat and Rural Development Assam, which states as follows. The corrigendum dated so and so is made a part of the next year. Okay. We have an exchange, contempt petition, cash flow. So that office note, this can,
So that may be fixed for here,
that, huh?
for admission. here.
Lordship, these also may be closed right now, this repetition,
No, no, that-
because his only contention was that he has been transferred inter-district,
Ah,
which he says was, which he was aggrieved with.
ah,
Later on, he was again, that transfer order was interfered with by a stay order
ah,
by the coordinate bench.
ah.
Later on, then he had been attached to the head office of the district.
Ah,
Now he is working as a head office in the district.
ah.
So as of now, he doesn't,
Remain.
Lordship,
So there's nothing remains.
yes, nothing remains right now.
Yes, Mr. Council, nothing remains.
Lordship, but the order is there, Lordship, the transfer order.
That transfer order is the corrigendum, Lordship.
This corrigendum, this annexure X should take care, no?
Lordship.
This annexure X should take care. Please, the instruction issued to Sri Hanaganda not to allow any official have concluded is hereby withdrawn. But
Lordship,
this does not affect the transport.
no,
Yes,
Lordship,
sir,
the transfer, he doesn't have any right to continue in a particular place of posting.
Okay.
He was transferred inter-district, which was agreed with. Later on, that transfer order is being interfered with, being stayed with. He has been attached to the headquarters of the district. Now he's working in the headquarters of the district.
You withdraw this writ petition for that with liberty to file a suit. Mr.
There is left.
There is some letter also for the petition submit. That in view of the corrigendum number so dated so issued by the Commission Panchayat Rural Development itself, you would like to withdraw the writ petition with liberty to file. If the need arises, Lordship. Mr.
A.K. Ghosh on,
Ghosh appears
Lordship, PNID.
in view of this, the prayer of the petition council is allowed, writ petition dismissed as withdrawn, with
I have checked the FIR vernacular. In the FIR, my name does not figure. These are somebody else. FIR talks of Asami Surab or Suhan. Suhan. So in the FIR, I'm not named because I've checked the SMS. Suhan. Subahan.
but there is one Sabahan here in page 2.
My lord?
In the FIR,
Yes, ma'am.
in page 2, Sabahan is there.
No, I've checked the,
Only here.
let me check the fair. English is, but in the, as the police has written that form, original FIR, I have checked, I'm not named.
Initially, you might not have been named.
Yes, but the fact remains that I am not named in the FIR.
Okay.
That you all have taken into consideration. FIR need not be the encyclopedia of all things. That we, your lordship is correct. But so in the FIR, I am not named. Now your lordship will come into your lordship has seen the postmortem report. The postmortem report says it is the third injury which is fatal from behind. First and second are all surgical injuries. Because he was operated, opened up, the first and two is not the cause of death. Now your lordship will come into the deposition of PW1. Before I take to your lordship, one more thing I will point it out. Your lordship will look at page 7.
Yes.
It's an elementary principle of law which the learned session judge has missed, my lord. Your lordship will see. Charge was framed under 149. To form an unlawful assembly, at least minimum 5 persons will require. Here it's only 4. Page 7. and nobody pointed it out.
Okay,
Then your lordship will come to page 10, the position of the PW1. Say, so mark नहीं किया है. I know the accused present today in the court. I can place two citations in regard to that 149 also. That it is not the case of unidentified. No, but your lordship will see only the charge is framed against 4 persons. You cannot frame a charge for 4 person on 149 because you cannot say that in the future during the trial some more person will be roped. So today we are framing a charge on 149. It can't be. Right, maybe in the FIR, if in the FIR there may be more, my lord, in the charge sheet there may be more, but after the perusal of the materials on record, if the court finds that only 4% can be charged, it cannot be a charge under 149. That's my respectful submission. And there are two citations on this point, my lord, I can place those judgments. Your lordship will take note of it.
yes,
Now your lordship will come at PW1, who is the informant and who claims to be the eyewitness. And your lordship has seen the narration of the events of PW1 in the affair. I have said that he is the informant, eyewitness, brother of the injured Ainuddin, PW4, uncle of the deceased, and he is an interested witness. Now, if your lordship looks into his deposition, I know the accused person present today in the court. I also know the injured and the deceased. On 27/9/2013 at around 5:30 p.m., that means in the evening in the month of September, I came to Riverside. Here, he gives a different location than the location he has given in the FIR. So the first he said that I came to the Riverside, having arrived at the bank of the river. This was never stated in the FIR. I heard hue and cry. I had also noticed Taher Ali and Subhan Ali armed with sticks. Your lordship will see in the FIR, Dow, Spare, and all those things. Now in the deposition, he on oath he says that I had also noticed Taher Ali and Subhan Ali armed with sticks coming running to the place of occurrence. Then I had seen Ainuddin Mandal was trying to catch hold of the knife in the hand of Subhan Ali. So there was a scuffle between Ainuddin and the appellant Subhan Ali, and he had seen him catching hold of the knife in the hand of Subhan Ali. Sorab Ali, by means of the stick in his hand, striking blow on the scalp of Ainuddin. Then your lordship will see. Next line. Ainuddin fell on the ground. Sobahan, by means of the knife, stabbed on the right side of the belly of Ainuddin. Ainuddin is not the deceased. Deceased name is Siddiq, my lord.
I think we'll adjourn. I'm not feeling too well.
Yes.
Lordship, wait for a minute. Material, so.
I'll only request that your lordship will not fix the matter on 2 to 8. Your lordship will take rest at 2 to 8. I'm out of station and Monday, Friday, I'm not here next week. It's because maybe that dry weather.
Matter the after 8,
After 10 on 10.
then we fix.
10.
12.
12. 12 also. So, that's what about that? What about the cabin?
No, we adjust it.
Yeah, yes, 12. 12 March.
12.
I'm for 9.
Okay. Your eyes has become green.
Okay.
Okay.